Good morning on this semi-cloudy day today. Good to see everyone this morning. My name is Nancy Lane. I am on the board of directors at North County Association, also a C.A.R. Director as well. I'm been involved in professional standards for, gosh, 20, I don't even want to say how many years, long time. And I am just thrilled to be able to work with you guys today on open house information. So I do need to read this disclaimer first, which is the following presentation is provided to North San Diego County Association of Realtors members and other real estate professionals for informational purposes only, and not as legal advice or to define the real estate profession's standard of care. The instructor's views are my own and do not represent the association's position. For advice regarding specific questions, please contact the appropriate professional and let me know if you have any questions, and I'm looking forward to it. So let's just kind of get started. Essentially, a lot of people are concerned about how the new rules are going to affect us with regard to open houses and how you deal with clients who come in either with an agent or really as the majority of the fear, so many who will not have agents thinking that they're just going to save that commission and end up with a smoking deal. And there's, of course, we all know nobody does any work in real estate. We just show 3 houses and then get checks. So we're just going to kind of walk through some of this information so that you guys are a little more aware of how we're working through this. So basically, the majority of the issues are around open houses are whether or not it's allowed, which of course it is. Nothing in the new rules prohibit you from holding an open house. And when you are holding an open house, how do you deal with those clients that walked in? So if an agent's holding an open house, for example, are they required to have every visitor who enters sign a registration sheet, a non-agency agreement, a buyer representation agreement? What is it that they're required to sign? And that's really on a case-by-case basis. Whether any of those documents are required to be signed or not depends on the interaction between the agent and the visitor. So you ask them the question, are you represented? And they answer yes or no, depending on whether they are. And so ideally, you as the agent who's holding that open house are going to have basically 4 forms available at that open house. And those are going to be your open house visitor non-agency disclosure and sign-in, which I call the Hawaiian Spanish form, the OHNA-SI, the buyer non-agency agreement, which is the BNA. That hasn't changed much except specifically with the explanation of what that means. The buyer representation and broker compensation agreement, everyone's favorite, the BRBC, and or the property showing and representation agreement, which is the PSRA. So that one is this sort of temporary one where you can show them just, a specific house, 3 houses, something like that. Very limited timeline, 1 to 2 weeks, somewhere in there. It's kind of I want to, meet for coffee or lunch before we actually go on a date kind of a one, right? So do you have to have all the visitors who are coming to your open house sign the Hawaiian Spanish form, the OHNA-SI? You should. And that's because it clarifies that relationship between you and that client who walks in as to whether they're represented or if they want you to represent them. And so then you ask them okay, somebody walks in and they say they want to work with me. Now what? Well, then you have the choice of the PSRA or the BRBC. So depending on the comfort level of both the client and you and whether or not they want to have you're my guy, you're going to represent me forevermore, then you would have them go with the BRBC. If they're a little hesitant, they're not sure, and you are maybe not either, then you can do the PSRA and have that be a limited timeline. So let me pull up some of these forms so that we can, let me make sure they're available. Okay, so. Okay, so this is the OHNA-SI form. And we're going to go through each of these forms on this, and you'll be able to see the actual form. So this is the OHNA-SI, and basically this is the clarification of what that kind of overall form is, right? So the visitor's intention to view the property, the agent who's holding the open house does not represent the visitor. The communication with the agent at the open house is for the benefit of the seller. You're clarifying carefully what it is that you're doing. So you are there representing the seller, not this buyer. The communication with the agent is not confidential. So if the visitor says, oh my gosh, I love this house, I want to buy it cash, then you're free to give that information to the seller. If the visitor writes an offer on the property through the agent, at that time, the agent will disclose if the agent and the agent's broker represent the seller exclusively or both the seller and the visitor. So essentially, when you have a buyer that comes through that open house or a potential buyer, you will, have that conversation with them. And are they represented? If they aren't represented and they want you to represent them, then you'll deal with that with regard to either the temporary or the BRBC. So what if I'm hosting an open house at a listing that is listed with another agent or broker? I know we don't recommend that. The C.A.R. attorneys don't recommend it. It's not technically illegal, immoral, or fattening, but it does create a lot of gray area that makes it difficult to clarify who you're actually representing. Because technically, when you're at an open house, you are representing that seller. And if you don't work for that broker who has that listing, then you are technically, unless you are a broker, working for two brokers, which is illegal in the state of California. So unless you're doing just the bare minimum, which is handing out a flyer and not showing that property and not having any discussions about neighborhood or anything like that, then you run the risk of violating the DRE's regulations or basically the state regulations regarding who you represent in that house. I spoke to the C.A.R. legal hotline who said that there is nothing wrong with it as long as you make it clear that I'm not representing the seller. Again, unless you are very, as I said, careful about how you talk about that property and you don't represent the seller. So not representing the seller is a very specific requirement. There are rules about what you can do for which a license is required. Essentially, there's a set of guidelines through C.A.R., which are what is possible for a non-licensed assistant to do with regard to an open house. So unless you're representing that broker who has that property listed, then you have to be careful not to do something for which a license is required in your dissemination of that information. So again, you can communicate with the agent at the open house for the benefit of the seller only. And the communication with the agents are not confidential. If the visitor writes an offer on the property, the agent will disclose if they are representing one side or the other. And that's when you would say, I don't represent the seller. But again, if you are doing anything for which a license is required, you again run that risk of that gray area. If a visitor wants to be represented by the agent holding the open house, the visitor should sign a representation agreement with the agent holding the open house at that time, the BRBC, PSRA, whichever one you choose. And this is the PSRA, which is the temporary one. So you have obviously the names of the parties to the agreement. So you have the prospective buyer, you have the broker name, you have the property address, and then you will have the timeline. So the representation period cannot exceed 30 days on this PSRA. So again, this is the PSRA, and this says that there is not there is a timeline that it cannot exceed, or you can have and then the resulting transaction, whichever occurs first. So if you literally put something in escrow on the 30th day, this doesn't poof. It goes into the timeline of that escrow. The amount of compensation that's agreed upon, you will have that discussion with your buyer. And the payments received by broker from seller. If the broker receives compensation from the seller, you cannot exceed that. So if you have a percentage that you've agreed to with your buyer, but the seller is offering a different percentage, you cannot exceed what you've agreed to with your buyer. The cancellation rights and notices are effective upon receipt as the base for this form, or you can specify a certain number of days, again, depending on your conversation with your buyer. Should we have neighbors who say they're only looking sign the OHNA-SI? Also, it's best practice. I understand in reality, some people are going to be very hesitant. But again, one of those questions is, the homeowner is letting people into his house, and he would prefer to have, obviously you're going to have that conversation with them, but he would prefer to have knowledge of who those people are. So I would ask, but you're not going to be a doorman and physically stop people from coming in if they don't want to sign something. I've cut this form and attached the top part to my open house book for signatures. Is this okay? Yeah, I mean, if you change a form, the C.A.R. Protections are no longer included with that form if you modify it. So if you just put it on the front of your page and just have that information there, it's not going to hurt anybody. But again, this is meant as a specific notification to those buyers. So you want to be careful that you stay and not really change that wording very much. What if the listing is in your broker's listing, but you're not the listing agent? You're still technically, the brokerage is who owns that listing. So you are working under that broker, you're fine. Can a visitor decline to sign? Sure, they can decline anything. It's up to you and your seller as to how hard you want to push that. And what you want to do with that. I understand you can with the modification of terms. I think you're referring to whether or not you can make more money. You can modify your terms. I'm just, that would be interesting because the comment has been brought up several times on the state call with the state attorneys, whether or not that was done after that offer was submitted. And it just, again, it gets into gray area. So the state guidelines are that you cannot change that. If you modify that agreement with your buyer and you have full understanding of your buyer, then that's up to you guys to do. I just think that the more I see how the DOJ and the feds are looking at this, the less I would do that. The more I think that makes you a target. But again, yeah, that's kind of your call with your brokerage and your attorneys. After the 30 days on the PSRA, if the client wants to go forward, and can we switch them to the BRBC? Sure, you can do that at any time, actually, or you can just extend for another 30 days. A lot of times those forms, and the BRBC, by the way, is only 90 days. But those forms are going to change anyway. If you've got a buyer who's been looking for 90 days and hasn't found a house, maybe they're going to look at a different area. So you're going to modify that regardless. So yeah, you can absolutely change it at any time to one or the other, actually. And you have a percentage or dollar amount on this form and or the BRBC in order to ask the seller to pay on the, yes, you have to have an agreement with your buyer. So agreement, as we know, when you go back to, Real Estate 101, it requires compensation, requires an amount, a time, a signature, an agreement, right? So that's one of the things that's required for a contract, is you have to have agreement on an amount. Okay, so the broker right to compensation is not fixed by law. One of the 7,542 times it says that in our contracts now, in case anyone was unaware. The real estate commissions include all compensation and fees to broker and are fully negotiable, always negotiable. The broker shall be entitled to compensation specified in paragraph 4B1, which is, again, the question actually you just asked, which is this right here, this amount. And from the prospective buyer during the representation period or any extension, the prospective buyer is shown the property by the broker and enters into agreements, right? So they buy it and you have an agreement already with that amount in place. That's what you're due. So if whether the broker involvement, whenever used in this agreement, means they physically entered the property and were shown by buyer, the broker showed the property prospective buyer virtually, the broker submitted to seller a signed written offer, the broker performed a market analysis that the property was introduced to prospective buyer by broker for one for which the broker acted on his behalf. So basically anybody in your office, this is broker involvement. So non-exclusive representation requires broker involvement. So the exclusive representation, and we kind of had a disagreement with this before, it does not require broker involvement in the same specific set of rules, but that's something that, again, having seen the reaction of the DOJ and the feds on this, that I don't know that there are very many people or many brokers who would fight that, essentially. I think if you didn't do anything, then your buyer might not be super excited about working with you. But again, everybody has relationships with their buyers. The timing of compensation is payable at the close of escrow. So if a buyer walks in and says that they're represented by an agent, do we have to sign it? Yes, you would have them sign the open house form, and there's a space on that form that says they're represented by a buyer. If you look back on that form, sorry, down here, their name, their email, and if they have an agent. That's where they would put that, if they have an agent. And that form, you want to have several copies of that. You can have just a blank sign-in form, and they can put their information on it. I actually had somebody say that they work in an area where people don't want to have their name known. So yeah, you can have separate pages. You can do this however it makes your clients comfortable. Having an open house sign-in sheet, as somebody mentioned, you can do that as well. But basically the information is going to be there, whether or not they're represented, if they have an agent, who that agent is. So if they have questions, you can direct the information to the agent. And then if they want to work with you, you have their name and information. So the timing of the compensation is the close of escrow, successful close. But if the acquisition is prevented by a party to the transaction other than the prospective buyer, when the prospective buyer collects damages, compensation shall equal 1/2 of the damages recovered, which I think is wild. And I'm interested to see if that actually gets collected or not. Payments are made through escrow. The prospective buyer hereby irrevocably assigns to broker the compensation provided for in the agreement. Irrevocable offer of compensation. Sound familiar? And the accounting for payments to broker, if broker also represents seller. And if the broker has signed a listing agreement with the seller of the property, the prospective buyer shall not receive a credit for the compensation the seller owes the broker for representing seller. So if you have an agreement and you have your listing agreement has on it that if you have an unrepresented buyer and you represent that buyer in order to close the transaction, he will pay you X amount. The buyer cannot then ask for that compensation as part of their package to the seller. Payments received from others less than prospective buyer's compensation obligation. If the seller agrees with the prospective buyer to pay all or part of the broker's compensation and seller does not pay as contractually required, The prospective buyer assigns to broker as a third-party beneficiary any rights prospective buyer has to pursue the seller for such compensation. So basically, take it out of the seller's hands, and it goes back to you as the agent and your brokerage. The cancellation of this agreement is based on how the agreement was signed, whether it is exclusive or non-exclusive, and they will be, the broker is entitled to compensation during the representation period if the represented buyer purchases a property or acquires a property for which there was broker involvement. That's the clear understanding of having shown that property, given them information on it, did the comps, physically walked onto the property with them, that kind of stuff. And before, during, and after the 5-day period, the prospective buyer is advised to notify any other broker of broker's rights under this paragraph. So in other words, you show a property to somebody, they decide that they hate you now, and they're going to go with their cousin Myrtle over here, and she's going to write the offer for them. If you have within 5 days notified, or excuse me, that seller has to notify cousin Myrtle that you are due a commission or compensation on that. May we offer a form with sample watermark for a proactive buyer who wants more time to read the form and is hesitant in signing any form at an open house? Well, the forms that, and we'll go over this in a second here, but the forms allow them to say, you're not representing me, I just want to see the house. And then they can contact you later if they decide they like you. So not really. You don't want to leave a form with an agent or excuse me, a buyer. That form is for the benefit of your seller or the seller of the open house, or you as the agent holding the open house. And it is so that that person is a known entity when they're viewing the property. Will there be a recorded version? Yes, it'll be on the page probably next week sometime. Possible dual agency. If the prospective buyer ends up saying, all right, I want you to work with me, you're the best ever, and you have them sign the form, then yes, they could result in a dual agency. The prospective buyer will act timely and in good faith to communicate and cooperate with the broker. So this is kind of an interesting and fun new factoid, and one of the things that I think is a benefit of our new world, and that is that the buyer is put on notice, essentially, that they have responsibilities and obligations as well, which means they have to give you their information so that you can provide that to the seller, but also so that you know what their purchasing power is, et cetera. And again, this was the question that was just asked. Prospective buyers attending an open house without representation, you are not required to sign a representation agreement to see this property in an open house. If you do not want the agent holding the open house to represent you, you should not sign this form, and you should read and understand the open house visitor non-agency disclosure and sign in the OHNA-SI. And all prospective buyers, if you have already signed a representation agreement with another broker, you should inform the broker of the name of that other broker and provide a copy of that agreement to this broker, or request the broker to obtain a copy from the other broker. You've already signed a representation agreement with another broker and you sign this form, you may be obligated to pay 2 different brokers if you visit this property. So if they want to just see the property and they don't want to be represented by you, this form, the OHNA-SI, which is this first one that we went through, says if the visitor wants to be represented by the agent holding the open house, the visitor should sign a representation agreement with the agent. So this does not obligate the visitor to anything. It says the agent does not represent the visitor. So if you want them to be, or if they want to be represented by you, they would sign the BRBC or the PSRA. One of those 2 forms would be what they would sign to obligate themselves. That OHNA-SI form does not obligate them. It just signs them in, and it clarifies that you are not representing them, that you are representing the seller. Okay, so then the final form, or the last one we've got, is the BNA, which is the buyer or tenant non-agency agreement. So this form basically says that the buyer, or if you're doing a lease, the tenant, understands that they are not represented by the agent. And that, so if they want to write their own offer and they don't want to have representation, then they need to sign this form. So if this is your open house and you have somebody that walks in and says, I'm just looking at the house, I don't want to be represented, and I'm not going to sign the BRBC or the PSRA, but then they decide they want to buy the house, then they say, all right, I'm not going to be represented by an agent. I'm going to represent myself. Maybe they're a broker already. Maybe they're just going to get advice from their Aunt Myrtle. And so they want to buy this property. Then you have them sign a BNA, which is a buyer non-agency. What if they don't list an agent and the agent doesn't bring them the open house, but then makes an offer and is using another agent? Depends. Did they sign an agency agreement with you? If they didn't, then they just saw that house and decided they needed an agent and got an agent and had them write the offer. So yeah, there is no protection for a non-represented buyer. If they just come through your open house and then buy it through somebody else, they bought it through somebody else. If you have somebody at your open house that signs something with you, then yeah, you would have a reason to basically work with them and have them sign your agreement. But if they don't and they haven't signed it, then they just came through an open house. It's just, there's not a lot you can do about that. You get people walking into an open house with no intention of buying. They're just looking what should be done in that case. Well, an open house by definition means that anybody can come in. It's open. And so you can ask for basic information like who you are. But essentially what you're doing by having an open house is saying that anybody can come in. So yeah, that's kind of looky-loser, a fact of life, both in real estate and I mean, pretty much everything. How many times have people walked into a store and not bought something? It's kind of the deal. Neighbors do it all the time. They're looking for design ideas, et cetera, et cetera. If a prospective buyer signs the OHNA that they are represented, is it okay to answer the questions, or should we ask them to have their agent direct all questions to us? Seems a bit rude or impractical, but what is the best practice? Yeah, unfortunately, all you can do if you do not represent that buyer is you can give them information. You can hand them the sheet. But if they ask you things like, how is this house priced for the neighborhood? Or what are the schools like? Or, what do you think about that, kitchen remodel? Or, is this room addition permitted? Things like that. You have to be very careful about answering because you do not have agency with that person. And you are answering questions, again, for which a real estate license is required. And if they have representation, but their agent is not with them, then yeah, I would say have your agent call me and I'm happy to provide this information. Unfortunately, we're prohibited from answering some of these questions because of the new ruling. Essentially, what you're doing is you're saying that the representation is the thing that basically drives that bus. Okay. So the buyer or tenant is represented by another broker. Any questions that buyer or tenant may have regarding the scope of the representation should be directed to the other broker. Just like I said, that's exactly it. You can soften it a bit, but essentially you can't represent them in even answering of questions because that creates a question on agency, et cetera, at least in the eyes of the DOJ. And it has to be clarified with that form, either the representation agreement, the BRBC, or the PSRA. And the buyer or tenant at this time is not represented by another broker. The buyer or tenant has the right to enter into an agency relationship with a real estate licensee other than the seller landlord's broker at any time during any negotiation or transaction regarding the property. So they aren't represented. They don't want to sign with you. But they can at any time. And I think that was the other question. If they came and saw the house and then buy it through another broker, that they have the right to do that. That is the way this ruling has been interpreted, essentially. so that the buyer and the seller are both in the driver's seat in terms of who represents them. So the seller or landlord's broker will act as the agent of the seller or landlord exclusively during any negotiation or transaction regarding the property. And statutory agency confirmation compliance is that form on the RPA as well that acknowledges receipt. So if you have, for example, you represent the seller and the buyer comes in and does not want to be represented, you just want to make sure you sign that form, not sign, you fill out that form with your brokerage and your name and check the box that says seller exclusively. And then the next set of boxes will be blank, essentially, because they would not obviously have an agent. Can you please provide the names of all these forms in the chat? Sure, I'm happy to do that. Okay, so so these are the OHNA-SI, oops. The BRBC, the PSRA, and the BNA. So those are the open house form, the buyer representation agreement, the dating representation agreement, and the non-agency representation agreement. So essentially that's all 4 versions of how you're going to have a buyer be represented. All right, so if you guys are not regulars on C.A.R. website, you should be. So one of the things, and I'll post a link. Let's see if I can pull this up real quick. Yeah. All right. So there's a link to a page on C.A.R. with business practices. It's got some, a couple of different versions of, one of them is kind of outdated because it says if your MLS hasn't switched over, which I don't know that there are any now that have not switched over. But if your MLS hasn't switched over, if your MLS has switched over, and then it's how to, some ideas of how to talk to buyers at an open house, et cetera. And I'll go through a couple of those here in a second. And again, one of the questions about if the buyer or if the visitor refuses to sign anything, but only just wants to look at the property. So again, that question is basically that whether a prospective buyer agrees to sign anything or not, they're welcome to come in the open house, unless you have written instruction from your seller, specifically don't let anybody in that doesn't sign something, or, I want to make sure that, anybody that comes in the open house is pre-qualified, or, some specific instruction. But basically the signing the OHNA-SI is not a condition of entering the open house, unless, again, you have some specific instruction. And again, you got to be a little careful about that and make sure that you discuss it with your brokerage and potentially attorneys, because you get into all kinds of issues about what is discrimination or what isn't. And you want to be careful in your discussions in that open house, again, with people who are not representing, or you are not representing, because you don't want to create an implied or an accidental agency, right? By merely talking to the buyer, sometimes you can make it very clear that you are representing just the seller. But when you are, trying to be helpful, which all of us are, sometimes it's difficult to see that bright line of when you're just talking to this person and telling them all kinds of cool things about this house. You need to be careful that you don't go over into the realm of representing them. And again, it's kind of a new definition. It's actually been in existence, but we haven't really paid attention to it for this length of time. And now all of a sudden it is becoming much more important. And you can always call C.A.R. Legal, and they will give you basically be as thorough as you can with your questions with them, but they will give you really good information and advice with regard to, so let me pull this up too, with regard to how to talk to people at open houses. Okay, so let's share this. This is that link that I just gave you. And it has on there unrepresented buyers and listing brokers. So what is an unrepresented buyer? And that's a purchaser who acts without any real estate representation, either from the listing broker, which could be the agent that took the listing, or another agent in the brokerage firm, or another brokerage company. So may a listing broker refuse to present an offer from an unrepresented buyer? Generally, no. The listing broker has a duty to the seller to present all offers, and unless otherwise instructed in writing, the listing broker should discuss this with the seller at the time of taking the listing. So basically, what do you want me to do, Mr. Seller, if somebody comes in and they're not represented? And there's a form on the RPA, or a section of the RPA, that allows you to add an additional compensation should you end up doing paperwork for an unrepresented buyer. A lot of agents are nervous or hesitant to do that because of the additional work. How do we find this quick sheet for the BNA? I'm not sure what you mean by the quick sheet for the BNA. The buyer non-agency, that form it's in zip form. If you just put in those, the short form that I gave you, that's in zip form. So in the documents on the right-hand side of zip form, that's where all of those documents are. Oh, this form, the document that I have on the screen. So that's, again, that's C.A.R. forms. And that, let me see if I can put this in the chat as well. If you will be able to link to it, you might. There's page 1 and page 2. So let me see, I'll give you both of them. So this is page 2. All right, let me go back to page 1. All right, so may a listing broker receive extra compensation if the listing property is purchased by an unrepresented buyer? Yes, as I mentioned in the RPA, paragraph 2C2, RLA, sorry, listing agreement, not purchase agreement, sorry, RLA. It allows the listing agent to request additional compensation if they represent both buyer and the seller. What might a listing broker at the time the listing is taken ask a seller for additional compensation? Yeah, you can. May a seller refuse to receive offers? Yes, but there's little incentive for them to do so. They can always negotiate. They can always go back and forth. They can always suggest a different price. There are a lot of ways that they can handle that. Refusing to look at it isn't really in their best interest, and I think you'd have a difficult time basically selling that as the proper method to move forward. What is an unrepresented buyer? So basically, it is a purchaser who acts without any real estate representation. Although technically, you could have an agent or a broker who is purchasing on their own and don't have any other representation. And so technically, they would be representing themselves. So just no outside representation. So the other question that's been asked a lot is, can you provide forms to an unrepresented buyer? Yes, because you are acting in service to the seller. It is in the best interest of the seller. You can ask them to present something to you, and you and your seller can then write on the proper forms the response to that in a format that the seller is acceptable to, and then have that be your presentation of that form. So you're doing it in service for your seller. That seems to be a pretty successful way to do it, essentially. Who writes the contract for an unrepresented buyer, and how about a request for a repair? Well, the contract for an unrepresented buyer, as I mentioned, they can either write something themselves. They can get forms at the local stationery stores. They do have some forms in there. Sometimes you can just give them the forms. Just make sure you don't fill out a bunch of additional stuff. Just put in essentially the address and the buyer's name. Let them fill the rest of it out. Or sometimes, and I've seen this where people have been working with an attorney and they give just a basic, piece of paper with their terms on it. You can then essentially turn that into a form by answering it on a form. There's a number of different ways to do it, but okay, so Shirley reposted that. If you can't see that still, we can send it in an email as well. But essentially it's on C.A.R. And it's the transaction center, and that you can go into quick guides, search quick guides in the top right, and you can find a lot of this information as well. It's just very helpful to have this, especially in this newer phase where everybody's learning all of the new terminology, et cetera. So how should a seller respond to an offer written by an unrepresented buyer? Again, you can just counter it as a straight counter depending on how it was written in the first place. You can rewrite the offer if it's too crazy or out of whack or something the seller doesn't want to accept. It's like any other offer, except the buyer will not be represented by an agent. So, again, depending on the situation, how you want to answer that will be a conversation between you and your seller. If the listing agent or another agent in the same brokerage as the listing agent prepares an offer for the buyer, will that buyer be represented by the brokerage company? If they have an agreement in place, yes. If they don't, or if they've just provided that paperwork for the buyer to fill out. If the agent fills out that paperwork and is actively involved in that buyer's process, then I think you have some implied agency there. And I think you might get into a question with your brokerage and or C.A.R. legal about that as to what the level of responsibility is. This is their, Q&A form here, which clarifies if the agent preparing the offer discusses the terms with the buyer and assists the buyer in completing the offer, then a buyer could believe the agent was acting on the buyer's behalf, and the agent could be deemed to represent the buyer. The listing brokerage would then be considered a dual agent. And when the agent fails to obtain the buyer's signature on a buyer representation agreement, the broker and specifically the licensee will not be entitled to compensation from the buyer. So basically you just put yourself at risk and wrote the papers, and you would not be compensated. So you want to be careful about what you're doing and making sure that if you have agency, that you have an agreement for agency, and that you write this stuff in place and it is clarified. The new business practices, the one that I was talking about, working with buyers before your MLS implements settlement changes. This is the first link that I put in the chat. And this really isn't in effect any longer because the MLS has pretty much switched everywhere. And this is working post-MLS changes. So basically, the MLS will no longer contain offers of cooperating brokerage. So you want to make sure that you have an agreement with a buyer and that you have the ability to then write in your purchase agreement and whether or not your buyer needs to have that compensation rolled into his loan, whether he's going to pay it himself, how he's going to handle that, and whether or not you want that to be included in the closing costs or not. Again, you write it in just like you would anything else, roof repair, flooring, and compensation. In the MLS, there are some MLSs, CRMLS is one of them, which allows for a box to be checked that says that the seller is willing to look at offers with that compensation included in the offer. Some of them are more specific. The C.A.R. does not allow anything to be mentioned regarding the dissemination. So if you have a $10,000 roof repair and you're also willing to accommodate a buyer and those closing costs, you cannot differentiate those in the MLS. What is the heading for this form? This form is under C.A.R. knowledge business practices. Again, I put the link in the chat, and it is, go back up to the top. Just the facts. Let's talk scripts, new business practices, resources, and it's under Knowledge Center. And basically what you want to do is you want to look through these, and this, I'm going to make them a little bigger just because otherwise it looks like ants on the screen. And you can download each one of these. These are before the MLS changed. Now it is after the MLS changed. And if the seller, if the RLA was already modified, so if you have a listing that's crossed the differentiation timeline, I don't think there's too many of them left, but in case they are, then you have a modification of terms. If you have a newer listing that's happened since this transition, it would simply have the correct form in place. If you haven't changed it already and you've got one in existence that is under the old rules, modified immediately because you're out of compliance. So, and an alternative to changing the listing agreement automatically is to just use the new version of the listing agreement, the 2024 version of the July 2024 version of the listing agreement. So here's where we get into the conversations, which I think is hysterical. Like it's like The View, right? We all have these conversations on the couch with our clients about the new business practices. So I heard in the news that the real estate industry is going through a lot of change. Captain Obvious. Of course, earlier this year, there was an agreement, and you can kind of go into all of these different. I think the key here and the biggest takeaway most of us have in practice of this change have seen is just basically clarifying the facts. So much of this information out there in the media is wrong and just blown up. And this allows you to have conversations with people that aren't, you know, crazy, essentially. Okay, so there's a couple in here that I haven't gotten to yet. Hang on just a second here. If the prospective buyer signed the OHNA that they are represented as okay, they answer the questions. Oh no, you have to give them to their buyer, to their broker. How are the fines enforced for open house compliance? There aren't fines for open house compliance. There are. Okay, so as an agent in the state of California, if you are working with a buyer, you are required to have a BRBC before you show properties. So if you physically trot on up to that house with your buyer, you have to have a BRBC in place in order to show properties. If that buyer comes unaccompanied, they can say, I have an agent, or they can say, I'm not represented. But there's not a fine for somebody, for example, who comes into an open house unrepresented. There's not a fine for you as the listing agent if a buyer shows up with his agent and the agent doesn't have his BRBC in his hand. That's his violation. You're not the cops. So yes, there are rules. Yes, we should follow the rules. It's in your best interest to follow the rules. It's specifically delineated in the federal agreement. But again, you're not a cop, and them not following the rules doesn't result in a fine. It might result in a violation at some point, but there's not people wandering around with their little, tickets for people who did it wrong. So to be clear, if they have an agent, questions should go through the agent, but if they sign the OHNA and do not have an agent, then we're free to answer their questions because it's made evident on the form that we represent the seller. Is that correct? No, that's not correct, actually. If they don't have an agent, you cannot answer their questions unless you are representing them. And if they do not want to be represented, then you are able to give them, for example, a printed flyer. You can give them the ability to, on that flyer, maybe you have some information links posted, for example, that kind of thing. But you cannot go into real estate detail like, this price per square foot on this house and the neighboring house just sold for this and this one's more upgraded and the schools are really good in this area and blah, 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 blah. You can't do that because those are considered showing, even showing the property. Like this is a mid-century modern home and it's in a great, it has this lovely elevated ceiling living room and, these are real popular right now. All of those things are based on your expertise as an agent, and you are allowed to only work with a registered or a client who has registered as your client. If they do not have an agent and they come into your open house, you are free to suggest to them that you would love to work with them. And that's where that PSRA comes in handy, because you can say, I can represent you just for this property. And that way I can answer all your questions and give you the information that you need. If they have another agent, they can work with their other agent. I'm happy to send him, your information that you requested. Or if they don't want to be represented and they're just there to look, then you need to be careful about how you answer the questions. Okay, I'm just going to leave this chat up because it keeps getting added to. How does it serve your client, the seller, if you can't talk about the house? Yeah, that's a question. And, if we had all of the answers about why the DOJ and the feds came up with this settlement and why they think we are, not being responsible to our clients by giving information, I would love to answer that question for you. I don't know how I just don't know why this specific set of rules are put in place, but I think we can utilize it to our benefit. And that is their belief is that if a buyer walks into an open house and wants to be represented by the agent, then they can. If they don't want to be represented by the agent, then they don't have to. And so if you're going to provide service for which a license is required, they're saying, the feds are saying, the agreement, the settlement is saying that you have to have a written agreement to do so. And it has to be clarified so that that buyer knows what he is going to be paying for your services. And you are clarifying what the extent, time, and duration of those services are. So it is meant to clarify the agreement and make sure that all buyers understand what they're agreeing to. And again, you want to make sure that you have clarifying conversations, both with the seller and with any buyers that come in through that property. I would love to work with you, Mr. Buyer. I would love to, be able to help you on this. Unfortunately, I am restricted by the rules that have been put in place with regard to my ability to answer your questions unless we have an agreement in place. I can give you a flyer, however, and I'm happy to do that. And you can feel free to look through the house. Unfortunately, depending on the question, I may or may not be able to answer. And again, you're going to have the ability to have a conversation with them about your services and what you can provide to them and why it's in their best interest to work with you. And that's what this really gets down to, and why it's a little bit intimidating. So one of the things that this goes through on these forms, which is the new business practices, is help in going through these conversations and the ability to clarify what it is that you're discussing. Okay, so we have two different chats going, so I'm flipping back and forth. When the agent brings the buyer at the open house, then that agent will be explaining all the details about the house. No, actually you can't. You can hand out a flyer and you can, you can essentially make sure they don't, go through the medicine cabinets and stuff, but you can't show, it's weird definition of what they mean by show, but you can't explain all the details about the house. Can you give a flyer of yourself if they are not represented? Sure. You, back in the day, when I first started in this industry, we did personal flyers all the time, personal brochures. Those were a big thing. But you've got them physically in your little clutches. I would have a conversation as well. If there's a flow chart, quick reference for the if-then situations for which forms to use. Well, yeah, the OHNA-SI, says, are you represented? And if you're not represented, it has the signature form on there, and it clarifies non-represented, represented, just coming to see the open house. Then you can either have a conversation with them and use the PSRA, which is the short-term one, or the BRBC, which is the longer-term one. So 30 days, 90 days, right? So you can use either of those two forms depending on the level, or you can shorten them. You can have a week if you want. If somebody is just nervous about working with agents and they feel like they're going to be, they're going to attach a luggage tag to their car and follow them forever, then maybe you have them sign just on that property. Again, this is all negotiable. You can work it however you want it to work and however they feel comfortable working. Where is the BNA in forms? Write BNA and it'll pull up. It's the buyer non-agency. So in forms on the right-hand side, when you go into zip form, on the right-hand side, it says forms, and you should be in the California Association of C.A.R. library. It'll pull it up in there. And it should be right there. I'm not sure what you mean. So if it's not in yours, you might need to make sure you're using an updated version and not an older, if you created, templates. If you use an old template, sometimes it won't load the new forms into an old template. So you might need to redo your templates. Okay, so any other questions? As a listing agent, do I need to have a copy of the BRBC from the buyer's agent when they present an offer or later if we enter escrow? No, because in the RPA in 3G3, there is a section, the SPBC, SPBC, no, SPO. There's too many, too many short versions of things. In that, there's a form that's actually going to be included in the RPA in the next go around, which is probably going to be December, and that will include what the percentage is that the buyer is asking the seller to include in the purchase price. So that sometimes a buyer or a seller is going to ask for the BRBC. They don't technically have to give it to you. You can ask them for it and see if they'll give it to you, sure. But there is a section for it on the purchase agreement as well. If you get a sign call for someone that wants you to show them the house, do you have them sign the OHNA if they don't want you to represent them? They just want to see the house? Sure. Yeah, absolutely. And again, we get into the safety aspects. There was just another realtor who was murdered recently. So all of us have to have that top of mind, both safety. We were all getting into the habit of asking for driver's license and that kind of thing. And this, by the way, I've heard a number of reports of shoppers, right, that are put out there by the feds to see if they can trap an agent into going to tour a property, which is a term we generally don't use, and just say, calling on your son, I want to go tour this house. And it turns out it's somebody who's trying to essentially entrap us and into breaking these new rules. So just make sure that you specify. I would love to. I am going to require that you sign that you either have an agent, don't want an agent, or or are unrepresented, or want to represent yourself, or whatever it is, whatever their version is, that they would sign a form to that effect. And yeah, there are shoppers, unfortunately, and we've had on the state call a number of incidents where they have actually, dealt with them. So do we need to take a whole stack of those forms? So there's like signatures for, I think, 7 or 8 on each form. So you can make a couple of copies of it. You can have that form on the front. I think somebody mentioned it, and then have the additional pages of their sign-in booklet behind it. As long as that information is clarified, and you can write just at the top of each page, included by reference page 1, which includes that information that you've gone over that with them. That's the thing that we want to be careful of. As with most things in contracts, you want to make sure that you are clearly defining what the agreement is, and that they understood what it was that you had them agree to and sign. Okay. So those 4 forms working together. So the OHNA-SI, the PSRA, the BNA, and the BRBC. Basically, you should have those 4 forms with you at an open house. And that should cover pretty much everybody that comes in. If they don't want to be represented and they want to write an offer, if they want you to represent them, you can have the BRBC. If they don't, or the PSRA. Short term, you could do just 1 property on that PSRA. Or show them something for a week or 2 days or whatever they feel comfortable with. Again, that's why we hold open houses, right? We start working with those people. We form a relationship with them. We create a connection with that person. And then we obviously want them to work with us. So have the paperwork there to support that if that's what they decide to do. Okay, guys, our time is up. I can't believe how quick these go. It's nuts. And there is a lot out there, but honestly, just talk about what you provide, and you can have that conversation all day long. I've been in the business X amount of years. I've worked with, dozens of buyers. I've worked in this community for a very long time. I'm more than happy to work with you. I have a number of people that I work with. I've got contractors. I've got, it always makes me think of the mermaid, the widgets and gadgets galore. So basically talk to them about what it is that you offer and how you are willing to work with them, and talk to them about how that is going to, create a wonderful relationship with them. All right. Thank you so much, everybody. I will see you, and stay, well, it's actually getting sunny out. I was going to say stay dry, but it looks like it's gonna. All right. Thanks, everybody.